I welcome everybody. As stated, I'm going to give a bit of a more fulsome introduction before we start our panel discussion. I want to welcome everyone again. I'm so glad to see you all here. Again, my name is Margaret Anderson. I'm a retired judge, and I'm really as proud as I can be to say that I'm the chair of the Board of Trustees of the National Judicial College. This is a crucial time for the judges of our country. It's essential that the judiciary operate as an independent and separate branch of government, as the founding fathers intended. It's really quite simple. The judiciary serves as an essential leg of a three-legged stool. Without that leg, the stool collapses. Without an independent judiciary, our system of government collapses. The NJC mission statement is, making the world a more just place by educating and inspiring its judiciary. I used to say that the mission statement says it all, but I now would add supports to the statement. We are lawyers after all, and we could argue that support is implied by inspire, and of course by educate. But perhaps we need to make it more explicit, because the NJC provides judges not only with education and inspiration, but with the training and support they need to withstand attacks on not only their rulings, but increasingly on their character and even their physical safety. Much is made in the media, especially these days, of the rulings of the US Supreme Court, of federal trial and appellate courts. And those courts and those opinions are very important, especially now. As Dean Chemerinsky has explained to us, they're more relevant today more than ever. Our program this evening is scholarly and it involves very important questions of constitutional law. But please also keep in mind that it's the local courts that make decisions that directly impact the vast majority of citizens. The family courts, the traffic courts, the hearing officer that decides if they keep their driver's license, the administrative law judge that decides if they keep their real estate license, the special education hearing officer that decides if their autistic child receives services. So while in the news we often hear about the US Supreme Court, and we should hear and we should keep up with those cases, and the federal trial and appellate courts, state and administrative law judges actually hear 95% of the legal cases in this country. If the citizens that appear in those courts and hearing rooms don't trust that they are receiving a fair hearing, that stool leg is weakened. The sturdiness, the strength of that stool is in serious danger. The National Judicial College offers more than 150 courses each year. It reaches over 12,000 judges, state, appellate, tribal, and administrative in every state and in other countries as well. These are the judges that are the focus of the NJC. Our college, over 350 volunteer faculty, board members, and support groups and professional staff, works very hard every day to carry the mission, to strengthen the stool that supports our democracy. I'm going to switch to introductions now. First to two groups of very important and very friendly folks, who some of you have met. First, the Board of Trustees held one of its meetings locally today here in Berkeley. So most are in attendance tonight. So I'm just going to ask them, they're out there, please wave if you're a Board of Trustees member. Thank you. And Claude, yes, our hardworking board. And as many of you know, we are presently without a president and CEO. We're working on that. But the college is being very ably run by our wonderful staff. And on to introductions. I've already introduced Dean Chemerinsky, who's very, probably thought my introduction was too long the first time, so I'm not going to do that again.
Thank you.
All right. So I'm going to move on to Judge Bernice Donald. So Judge Donald served on the United States Court of Appeals for the Sixth Circuit for 12 years until her retirement in 2023. She served as a bench officer for a total of 40 years. I can't really quite believe that, including as the first African-American woman to serve as a bankruptcy judge. Her biography is replete with firsts, which is understandable given her story, and I have to just mention a couple things. Because she started grade school the year Brown versus Board of Education was decided, and attended segregated schools in northern Mississippi until 11th grade. She was the first in her family to attend college, and she balanced school and work during both undergraduate and law school at the University of Memphis. In addition to her impressive career on the bench, Judge Donald has traveled the globe, speaking on the tenets of democracy to many emerging democracies and those trying to break the bonds of authoritative governments, including in Turkey, Brazil, Russia, Kazakhstan, Kyrgyzstan, and South Africa. She is the NJC Jurist in Residence on the rule of law. But I wonder if among her many great achievements and awards, the fact that in 2024, the street that runs in front of the federal courthouse in Memphis was named the Bernice Bowie Donald Street. Might be one of her favorites. Welcome, Judge Donald. Professor Zachary Price teaches and writes about constitutional law, administrative law, and criminal and civil law enforcement at the University of California Law, San Francisco, where he holds the Eucalyptus Foundation Endowed Chair. His scholarly work focuses on constitutional questions generated by the current political polarization. Professor Price's book, Constitutional Symmetry, Judging in a Divided Republic, was published in 2024. Leading national news outlets regularly turn to Professor Price for insight on timely legal controversies involving constitutional limits and executive authority. A few facts about his background is that he clerked for Supreme Court Justice Anthony Kennedy. Before entering academia, Professor Price served for 3 years as an attorney in the U.S. Justice Department's Office of Legal Counsel. Professor Price is new to the NJC community. I drafted him, and I'm so grateful that he accepted my invitation. A very special welcome to our newest speaker, Professor Price. So a word about format. We're going to begin with a question for each speaker, and they will have about 10 minutes to answer. We will then have some additional questions we will call lightning rounds that will go a bit more quickly, followed by some time for questions. And Joy will act as timekeeper and mic passer. And we're going to begin with a question for Professor Price, because we're going to jump right in with Professor Price. Professor Price, in your new book you wrote, "If we cannot agree on what the Supreme Court should be doing, how could we agree on how it should be changed? Ultimately, the task of mitigating the destructive political dynamics surrounding constitutional law must fall on the judges and justices themselves. What do you believe is the role of judges in preserving the Constitution and rule of law?"
Thanks very much. Okay, there it goes. Sorry. Well, first of all, let me just thank Judge Anderson and everyone else with the National Judicial College. It's really great to be here. It was a wonderful event. It's a real honor for me to be up here with this distinguished group, and thanks to all of you for coming. So, you asked about my book, and in particular, my suggestion that judges and justices have an important role to play in mitigating current challenges surrounding the rule of law and constitutionalism. I think I should say at the outset that, as Judge Anderson was suggesting earlier, I think the most important thing judges can do is just to follow the law objectively, model kind of objective legal reasoning in cases big and small. I think that's particularly important right now, where we have a lot of kind of opportunistic approaches to the law in ways I'll talk about. So that really central function of judges is really critical to maintain. But I want to talk in keeping with the themes of the book at sort of a higher level about the kind of political context of current constitutional law and the challenges I think it presents for courts. And what I propose in the book is that when it comes to constitutional questions, judges should favor, when they can, understandings that are what I call symmetric, understandings that work equivalently for interests on opposite sides of key societal divisions, rather than kind of protecting one side at the expense of the other, rather than sort of implementing a partisan view of the Constitution. So What would that mean in practice? I think we actually have a lot of law that operates that way. The First Amendment is a great example. Modern free speech doctrine generally requires content neutrality or viewpoint neutrality in speech regulations. It's not a particularly historically well-founded approach to the First Amendment, but it is symmetric, and I think that sustains it. It means that if you're disappointed with the result in one case, you can appreciate that the principle equally protects speakers you care about more in future cases. So in principle, it sort of encourages kind of mutual toleration, tries to interrupt the potential for a downward spiral of repression. So I think we should be trying to orient constitutional law this way in light of kind of some current trends. And so I thought I'd say a bit about what I see as the current challenge and then why that's a good solution, and then maybe say something broader about those of us who aren't judges. So to start with the challenge, I mean, you're no doubt aware of this, but over the past 50 years or so, our political system has come to be organized around two quite distinct and fairly ideological political parties. That wasn't really the case earlier, but our political system has just become much more divided and rivalrous and kind of full of conflict. And I think that puts a lot of strain on the constitutional system. It leads people within the political branches to pursue short-term policy wins at the expense of long-term values, creates incentives for repressive behavior that threatens civil liberties. And really the central function of the Constitution is to put brakes on that type of behavior, creates kind of rugged rules to govern the political system, guarantees basic civil liberties. But another challenge is those same kind of political divisions have infected constitutional law and legal interpretation. And again, that's probably familiar, but I think we have these kind of competing visions of what the Constitution is about. Progressives, by and large, view the Constitution as advancing social justice, conferring broad federal power, allowing flexible administrative solutions to challenges like climate change. And at the same time, they understand to limit state and local police authority, guarantee sexual and reproductive autonomy, among other things. So we've got that sort of progressive vision on the one hand. On the other hand, conservatives generally interpret the Constitution to protect traditional religion, limit gun control, limit administrative governance in some ways, while at the same time allowing state-level regulation of moral questions like abortion. So we have these two distinct constitutional visions that line up pretty well with the policy preferences of the two political coalitions advancing them. And to some degree, this has always been a feature of American politics, American constitutionalism, but it's taken on a particularly sharp character recently, and in some ways the degree of division, particularly on the Supreme Court, is actually quite new. It's only since the appointment of Justice Kagan in 2010 that all the justices on the Supreme Court appointed by Democratic presidents are recognizably distinct in outlook from all the justices appointed by Republican presidents. So even within that context, judges, they have theories of interpretation. Justices on the two sides are hardly just channeling their politics into the law. But at the same time, any theory generates hard cases. And, as I said, those two competing visions line up pretty well with the policy preferences of the two major parties. And it's pretty easy to be cynical about how cases tend to come out. So I think altogether this is a bad combination. The political environment is making durable constitutional rules particularly important, while at the same time encouraging opportunistic approaches to interpretation. I think the result is a lot of public cynicism. I think it threatens judicial legitimacy, but also could kind of imperil the whole notion of shared constitutional commitments on which the rule of law, our democratic system, really ultimately depends. So I think we need to find ways to push back against those trends in a kind of self-conscious way. So that's really the central challenge as I see it for constitutional interpretation, I think for the rule of law more generally. So in that sense, it's the bad news. I think there are some points of good news. The first is that I think judges are actually aware of this problem, looking for tools to manage it. And so my goal in proposing this idea of favoring symmetric interpretations is to provide that sort of tool. I think it's also kind of implicit in a lot of things judges do, like probing questions at oral argument. In law school classrooms, you often kind of test principles by flipping around the politics of the situation, seeing if the principle still works. I think that carries a kind of inchoate aspect of this preference or symmetry that I'm advocating. But in any event, I think that judges are looking for those sorts of tools. It's already a kind of implicit feature of judicial practice in some ways. And then also, I think it's actually something kind of implicit in the Constitution itself. The framers were certainly well aware of this problem of partisanship. They called it the problem of faction. George Washington worried in his farewell address that it could produce the ruin of public liberty. So they were certainly aware of this problem. They wanted the Constitution to constrain it. And then, as we all know from Hamilton, if not from other sources, the musical, acute partisanship became a central feature of the early republic, and the Supreme Court under Chief Justice John Marshall behaved in much the way I recommend. He looked for ways to kind of curb destructive practices like treason prosecutions, unchecked executive power, in ways that would equally restrain both sides. So I think if you put that all together, I think looking for these kind of more apolitical, symmetric understandings is something that should appeal to judges' societal role, their self-understanding. I mean, judges don't want to be perceived as result-driven partisans. They want to be understood as kind of stewards of the law. And so this appeals to that, while also according with kind of deeply rooted values in our constitutional tradition. So what would that mean in practice? And I gave you the example of the First Amendment, but I think it has application in a lot of other areas. Federalism is an example where we should be looking for principles that work equivalently no matter what sort of state you have or what sort of federal administration. I think it can help with administrative law, equal protection, and other things. And I'm happy to talk about all that, but maybe just to conclude with a broader point, I think this also has relevance to the broader public, those of us who aren't judges. I think it's important to remember that disagreement is inevitable in democracy. It's not necessarily a bad thing to have deep disagreements, but concepts like the rule of law and democracy are really procedural. They're ways for managing those conflicts, getting to outcomes that we can accept. But as with constitutional law, I think there's often a tendency to try and weaponize those ideas and say, beat up on the other side and not accept that sort of general character that they should have. So, I think it's important to ask, if you're troubled by something, is it really because it's illegal or undemocratic, or is it just because it's leading to a bad outcome from your point of view? And I think if you're not a lawyer or not versed in the issues, it's really important to look for sources of information that are not always coming down the same way, because if they are, there's a good chance they're not really reflecting an impartial commitment to the law as much as an effort to advance one of those rival legal constitutional visions I was talking about. So just to conclude, I think we have a lot of challenges. I think there's a lot to worry about. But to end on a positive note, I do think the inclination to think this way is quite strong in much of the country. I think people care about the distinction between law and politics. I think it's especially strong in the legal profession and stronger still in our state and federal judiciaries, which again want to be perceived as professional and credible guardians of the law, not aligned with a political movement. So I think we have a lot of resources to draw on, but I do think we need to be more self-conscious and deliberate about it, given the problems in our political environment. So thanks very much.
Turning now to Dean Chemerinsky. You recently wrote, "I am neither optimistic nor pessimistic. I am petrified for the future of American democracy in light of what has happened in just 8 months. We all should be very afraid about what has happened and where this is leading. What do you believe are the keys to preserving American democracy or reversing the slide into authoritarianism?"
Thank you. It's wonderful to have the opportunity to be part of this terrific panel. What we've seen since January 20th, 2025 is unprecedented in American history. Let me talk about three things that I see and then answer your question directly. And I think these three things explain why I truly am petrified. I am more afraid for the future of American democracy at this moment than I ever imagined being. One is, we've never had a president engage in such systematically illegal behavior. And we can come up with so many examples of this. I gave some during the last hour. The Constitution is clear that everyone born in the United States is a United States citizen. But President Trump issued an executive order to rescind birthright citizenship. The president has no authority to use the troops for domestic law enforcement purposes. And yet, that's what's happened in Los Angeles, in Washington, D.C., in Chicago, and in Portland. And the presence of military troops in cities is chilling to me. Troops are trained very differently from the police. Police are instructed with regard to being restrained in the use of force. Police are trained with regard to protecting constitutional rights. The military is taught how to use military force in war situations. That's why there is such a norm in this country against using the military that way. There's no such thing as martial law in the United States, but seeing the troops playing this role in major cities worries me that that's the path that we're now traveling. What the president has done with regard to impounding of funds is illegal. Congress has the spending power. The president doesn't have the authority to refuse to spend money appropriated by Congress. There's a federal statute, the Impoundment Control Act of 1974, that's clear that the president cannot impound and refuse to spend money. The president has no authority to abolish departments created by Congress. The Department of Education, the United States Agency for International Development were created by Congress. There are so many instances over the last 9 months where I've read something in the news that the president is going to do, and my response is, that's illegal, that's unconstitutional. And then I see the president doing it anyway. To give one more example of this, which affects all of us in universities, the president has no authority to cut off money to Columbia, to Harvard, to University of Pennsylvania, to Brown, to Cornell, to Northwestern, to UCLA. The president asserts he's doing this because those campuses were deliberately indifferent with regard to anti-Semitism. But if that's why money is cut off, Title VI of the 1964 Civil Rights Act is quite explicit in the procedures that have to be followed. There's to be notice, there's to be a hearing in front of a neutral hearing examiner, there have to be findings of fact, there's to be 30 days notice to both the House and the Senate before money is cut off, and money given off only for the part of the program that's found to discriminate. None of these were followed, so the cutoff of funds is blatantly illegal. We've never seen a president to so try to aggrandize and increase the powers of the presidency. We see this in many different areas. I mentioned some in the last hour. The president claiming the power to fire anyone in the executive branch. I talked about the claims of this with regard to high-level officials, commissioners of the National Labor Relations Board, the Federal Trade Commission, the head of the Merit System Protection Board. But President Trump has also said he has the authority to fire anyone in the executive branch. In other words, that civil service protections that have existed since the 19th century are unconstitutional. No president has claimed the authority to impose tariffs in the way that President Trump has done, with enormous economic and human consequences. No president has claimed the authority to control federal spending in the way that President Trump has done. And I go on with examples. And third, no president has ever used the powers of the office for retribution in the way that was seen from President Trump. Take the actions against law firms. The first law firm to be targeted was Perkins Coie, and the executive order imposed sanctions that would have put that law firm out of business. It was said that the lawyers there could not go into any federal building, which means they couldn't go into a federal courthouse. It said that the lawyers in that firm, if they represented any clients, the federal government would not contract with those clients. In other words, any business represented by Perkins Coie could not have a contract from the federal government. It revoked the security clearances of all of the lawyers in the firm. So you have to ask, what did Perkins Coie do that would deserve such punishment? The executive order is explicit. They represented Hillary Clinton in 2016. Two other law firms that were sanctioned, Wilmer Hale and Jenner and Block. The same punishments were imposed on it. What did they do? Well, one of them employed Robert Mueller when he finished his government service. The other employed lawyers who had worked for Robert Mueller. And of course, it was Robert Mueller who had investigated President Trump and the link between the Republican campaign in 2016 and Russia. Fourth law firm that was targeted was Sussman Godfrey. What did it do? Well, it represented Dominion Voting in suing Fox News, a case that Fox settled for $750 million. What was stunning to me about these executive orders is they were explicit that they were all about retribution. Now, all four of these law firms have sued. All have won in the federal district court in front of 4 different federal judges. But the retribution goes on. Look at the indictment of James Comey. Look at the indictment of Letitia James. Look at the indictment yesterday of John Bolton. These are entirely for purpose of retribution. The United States attorney who would not indict James Comey was fired, so somebody would be appointed who would be willing to do this. President Trump has identified who his enemies list is and wants to fire them. If you put all of this together, you can see why I say that I'm so petrified. If there is a path towards authoritarianism in this country, this is it. So what can be done about it? Who are going to be the checks on the president? It's certainly not going to be the people who are around President Trump. Can you imagine Pete Hegseth, Pam Bondi, Kash Patel being the ones that say, President Trump, no, you can't do that? They're enablers. So far, Congress hasn't been willing to serve as any check on the president. So the checks have to come from the courts. And thus far, the federal district courts have been terrific in checking the president. In literally not just dozens, but hundreds of instances, they've issued preliminary injunctions. If you haven't seen it, I commend to you a full page that was in the New York Times in the Sunday Review section in July. And it had quotes from district court judges across the country declaring unconstitutional Trump executive actions. And they identified the president who had appointed the judge. And you saw it was both judges appointed by Democratic and Republican presidents. The courts of appeals overall have been strong in checking the president. Unfortunately, the Supreme Court hasn't been. In almost every matter so far, the Supreme Court has affirmed the president's action, stayed the preliminary injunction. Ultimately, if the guardrails of democracy are to hold, it has to come down to the judiciary and the Supreme Court. And the fact that the Supreme Court so far has been a rubber stamp for President Trump and not a check on President Trump is part of why I'm scared. But to conclude my answer to your question, I think there's things that all of us need to do. I think we all need to be very informed and help inform others. I've heard too many people say it's too depressing to read or listen to the news. We can't afford that at this moment in time. Second, we all need to get involved. There are many organizations that are fighting hard against this. They need our support. To the extent that you are lawyers or law students or not involved in the law at all, they can use volunteer assistance. They can use financial assistance. We can all find ways to be involved in helping people. If you're lawyers, there are a lot of people facing deportation and visa revocation who need representation. And finally, we've got to find ways to speak out. Maybe it's with regard to letters to members of Congress. and some actually pay attention to the letters that they receive. Maybe it's petitions. For those of us who can, it's writing op-eds. Maybe it's going to rallies, including tomorrow. But I believe that democracy dies in silence. If the people speak out, democracy will survive. But at this point, not quite 9 months into the Trump presidency, I am petrified.
Thank you, Dean. Switching over to Judge Donald. Judge Donald, how do the minimal unvetted decisions by the Supreme Court, the so-called shadow docket or emergency docket, impact the ability of a sitting judge to do her job?
Okay, great. Well, first of all, I want to thank you for being able to participate on this illustrious panel. I mean, sitting between these two law professors is pretty daunting. And trying to come behind Dean Chemerinsky and talk about the impact of the shadow docket is really something that I didn't really consent to. You've already heard what he said, and I could just say I concur. But it does make it difficult because, as he mentioned, the shadow docket is generally viewed as being for emergency matters. And he noted the exponential increase in cases decided on the shadow docket, which really give little and sometimes no guidance to the lower courts. It just says, you're wrong, or we decide this, and doesn't give reason and rationale. And there is no development of that record beyond what happened at the district and the appellate courts. And so you don't have that reasoned decision to guide the judge. No full briefing. We don't know whether the court decided it this way because they had a bad day, or because of political influence, or because some personal decision really moved them to decide that. And so it's a lack of clarity and a lack of guidance, which is what the lower courts depend on. I mean, even if you think about cases that the court has decided, if really the purpose of the emergency docket is to decide those cases that really are emergencies, what makes it an emergency? Is it just because we want to give relief to someone on an expedited basis? Have we really eliminated the standards of the emergency doctrine? I've heard individual Supreme Court justices say that this is really much to do about nothing, that the court really considers the docket as a whole. They decide those things on the shadow or emergency docket only when there is an emergency need to decide that. But again, the court is deciding that there is an emergency need in that instance. And it looks to the public sometimes not like an emergency need, but like a strong desire to intervene at a point in time and to provide relief. I want to go back, though, from that and just talk about something that I think goes back to what Judge Anderson said about the stool and about our three branches of government. I am the Gabelli Rule of Law professor at the National Judicial College. And we talk to a lot of people. The college trains judges, but also does a good bit of work in community, because we know that these institutions all stand on the floor of the public. And if there is not strong understanding, commitment, and participation by citizens writ large, then we are, of course, in trouble. The folks sitting in here are law students, law professors, judges, and others, and you know the importance of today's subject. But people out there in communities across the country do not have that same understanding, that same breadth of knowledge, that same institutional involvement and engagement in these topics. When we talk about the rule of law today, it's almost been relegated to a bumper sticker. And if you ask 10 citizens, what does that mean? They will give you a number of different answers. We know that the term rule of law embodies principles of equal treatment of all people before the law, of fairness, and both constitutional and actual guarantees of basic human rights. Implicit in rule of law is the notion that government authority may only be exercised in accordance with written laws which were adopted through established procedures. And this principle is an important safeguard against arbitrary rulings in individual cases. To a lot of people out there that I talk to in communities across the country, they do feel and sense a certain arbitrariness, and they point that to partisanship. They look at the courts now with suspicion. They believe that the law serves certain people, that it serves those who are wealthy as opposed to those who are poor. They believe that justice is not blind, that justice favors certain populations of people before the court. To the extent that those kind of feelings become more pervasive, that really undermines the ability of the court to do the job that the courts are sworn to do. Because we as judges, we as the courts don't have an army, we don't have the powers of the purse. We depend upon the consistency, the integrity, and the confidence in our work by citizens who are served by the courts. And while the media normally focuses on these big issues, the ones that Dean Chemerinsky and Professor Price have talked about, it's important for everyday citizens to understand, and they do know, that they want to be able to go into a court if there's a family law situation and get relief that is not influenced by the political affiliation of that judge. If they have an administrative matter, they want to be able to go into the courts and be treated fairly. If there's a criminal matter, they want also to know that the judge is not going to have a predisposition because of anything about their arbitrary characteristics of birth. They want that case to be decided based on the facts and the law. But there is an abiding belief in communities that the blanket of justice does not cover all citizens evenly. There's a belief that some citizens are left exposed by the covering of the blanket of justice. I want to go back a little bit because in my introduction, Judge Anderson talked a little bit about my upbringing. And I want to tell you that when I grew up, all of those years ago, in a small town in Mississippi, which of course was one of the states in the United States of America. So I was born a citizen. But talking about these guarantees of fairness and equality, there was an exception for folk like myself and my sister, my parents and my older siblings, because even though the wording of the law applied to us, provisions of that law were withheld from us. I still have two older sisters living, one still in Mississippi, one in Tennessee, and they were well into their 20s before they had the right to vote. I still remember people coming into our community. Some of them were from California, some were from New York, and some were from other places, who had to take my sisters and other African Americans through the process of how to vote, had to be there to make certain that they stood as a barrier between the people who were enforcing the elections, so that my sisters and others who looked like them were not barred from voting simply because of their race. They still talk vividly about that experience, about the fear, about the intimidation. And there were other people in my community who are still living who did not have the experience they had. They simply could not vote. My mother and father, for many, many years, they had probably 4 or 5 children before they got that right to vote. And so I'll leave you with this. When we talk about these issues, they're all important. But as Judge Anderson said, the judiciary, the legislative branch, and the executive branch are part of this three-legged stool. And all of them must be strong to support the notion of our democracy. But that stool must sit on a strong foundation, and that's the citizens here who must be committed. We have always had good, strong laws. The weaknesses were, though, in the enforcement. Laws are not self-executing. If we do not have men and women of commitment and of courage and of vision, then our laws are just words on paper. We have to be engaged, involved, and vigilant.
Perfect, thank you. I'm going to take it back to we have what we call the lightning round. Okay. And, I'm not sure exactly which of these questions would appropriately follow that very passionate talk that you gave Judge Donald. But I'm going to go back to the question that we have about judicial independence. So, what does judicial independence look like, and why is it important? That seems the most appropriate question. So, let's start with Professor Price.
Well, I'd say it formally it means that, judges are immune to certain types of political control, can't be fired based on their decisions or have their pay reduced or things like that. But I think really what we're getting at is we want judges to be able to impartially follow the law and apply it, without fear or favor. And I think that's critically important for the law. It's also important for democracy, because when people succeed in getting laws enacted through the political process, they need to know that those are going to be applied in the way that was intended.
Okay, thank you. Yeah, this is a 2-minute. Dean Chemerinsky, judicial independence. What is it and why is it important?
I agree with Professor Price. Judicial independence is that the judge should decide every case based on the judge's best view of the law and the facts. And anything that compromises that is undermining judicial independence. I think when we speak of judicial independence, it's often discussed separating decisional independence, what I was talking about, but it also there's institutional independence in terms of the courts not being undermined. If Congress would eliminate funding for the Supreme Court or for the federal judiciary, then that would undermine the institutional independence. And it's interesting when you ask, why does it matter? If you go back and read the Declaration of Independence, one of the grievances that was there was how the king was undermining judicial independence, so the judges couldn't decide cases based on their best views of the laws of the facts. I think we've seen a great deal of threats to judicial independence just since January 20th. There have been 6 instances of district court judges being subjected to impeachment resolutions in the House of Representatives just because of disagreement with them. In fact, as soon as a judge had issued a preliminary injunction against the Department of Government Efficiency, Elon Musk said that judge should be impeached, and it was followed by an impeachment resolution. There have been an incredible number of death threats to judges in terms of threats to the judges' safety to try to intimidate the judges. There's also been the assertion by President Trump and Vice President Vance that they don't have to follow what the judges say. President Trump said, and I quote, that he who saves the country violates no law. Vice President Vance has said that the president doesn't have to follow judicial orders inconsistent with what he perceives executive power. All of this, I believe, is about intimidating judges and trying to undermine judicial independence.
Judge Donald.
I agree with my co-panelists. I would say that judicial independence does not mean a lack of accountability. It does mean being committed to uphold and follow the law, to make decisions based on the law, not on external factors such as political ideology or religious beliefs or anything of that nature. We must be laser focused on the law, and sometimes that can be very painful because the law sometimes requires or dictates outcomes that are really difficult. But as judges, we don't make the law. We take an oath to uphold the law, and we try to find to base those decisions on the law as best we understand it, and that's what we each try to do. I want to say one other quick thing, that one other thing that can impact judicial independence, and I see this with my colleagues in the state legislatures when they are disappointed or they disagree with things that a court does, they will try to exert external pressure through budgetary processes, withholding budget, and often criticizing judges. But judges are sworn by oath to uphold the law, and we should be independent to do that.
Thank you. I wonder, Judge Donald, I'm going to break this a little bit to
Okay.
say, in your international work,
Yes.
do you have anything to add based on what you've seen internationally about the concept of judicial independence?
One of the first places I went to talk to judges was back in 1983 in Bucharest, Romania. And there was a horrible situation for judges in that the political party, the Ministry of Justice and their people were actually engaging in telephone justice. They were actually exerting direct influence on judges by calling in and telling them what they should do. I found that kind of influence in a number of places around the globe. But as judges have worked to secure and be seen and work with people to help them understand the importance of having decisional independence and being able to stand against those external pressures, I think you're seeing increases. You know, the World Justice Institute does an index on rule of law, and part of that rule of law index deals with judicial independence. And we can see over the years, the last couple of decades, that level is rising from all these countries around the world. And I think we should all be concerned about the things that Dean Chemerinsky has said about the things that are challenging our system that are threats to judicial independence.
Well, we're coming up to the end of the evening, and I know we all want to have some delicious snacks and drinks. So I want to say we hope you found this program interesting and even provocative. And I have two thoughts to share in conclusion, mainly because I couldn't choose just one thought, but they're related. So the first, many in this group have heard me reference before. It's from Tim Snyder's little book, On Tyranny, 20 Lessons from the 20th Century. Lesson 2 is defend institutions. In reading it, I'm reminded of the assumption I frequently hear that the judicial system is strong and will be just fine. Professor Snyder disagrees, stating that institutions do not defend themselves. They need champions. I think that Dean Chemerinsky and our other panelists would agree. And indeed, judges in particular cannot, in most cases, defend themselves. He suggests that we all choose an institution we care about, whether a court, a newspaper, a law, and take its side. I've chosen the National Judicial College as one of mine. The second is a quote I saw in an exhibit in a recent visit to Washington, D.C. I was there representing the college, and I had a free afternoon to browse some museums and monuments. And it is this: change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change that we seek. I want to thank our panelists. I want to thank everyone who helped with tonight's program and event. We have a few little gifts for our panelists. It's something different for each one. They're over there. I forget which one goes to each one, so I need some help from Joy. So thanks to all of you, and thanks for coming, and please join us for some refreshment and